Okay, we're going to start. Again, good afternoon, everyone. My name is Peter Neufeld. I am a partner at the firm Wagner Sidlowski LLP, and I'm a co-chair for this Lunch and Learn series, along with David Friedman. This Lunch and Learn series has been on will challenges. Thank you so much if you've already been attending previous seminars. We've already covered a lot. The subtopic today, I think, is going to be really important and interesting for the attendees. It's on the role of the drafting solicitor in a will challenge. We have an article or blog post was prepared in advance of today's seminar. It's been posted on our website. If you haven't reviewed it, I encourage you to do so, and I'll have Maddie post a link to that article in the Zoom chat, so please check that out. Again, as I always say, we've got a few housekeeping notes. Make sure that your microphones are muted at all times, unless, of course, you're going to be asking a question orally. And then when you're done asking that question, please ensure that you go back on to mute. Please also note that today's seminar is being recorded. So we have two presenters today. Brad Phillips is a senior partner at Wagner Sidlowski LLP. He has been a litigator throughout his career with a diverse practice history, including now estate and commercial litigation. And that also includes doing professional negligence work, professional negligence defense, and coverage work for Law Pro in both estate and non-estate matters. So, of course, very applicable for today's discussion. He'll be joined with Tanisha Tulloch, who is a partner at Torque and Mains LLP in their trusts and estates litigation group. And she practices commercial litigation, professional liability defense, and of course, trusts and estates litigation. Her practice includes all aspects of estates, trust, capacity, fiduciary, and power of attorney disputes and guardianship issues. She acts for individuals, trust companies, government agencies, and other institutions. Big thank you to our sponsors for today. We have the B'nai B'rith, Concentric Trust, Scotia Wealth Management, Torque and Mains, TD, as well as BMO Trusts and Estates. This event and all the previous seminars and future seminars on this series are complimentary because of them. So thank you so much. If you've enjoyed our seminar, we ask that you consider making a donation to the B'nai B'rith Canada Food Program if you haven't already. Or if you'd like to make a further donation, please feel free to do that. The link for that is going to be included into the chat for this Zoom. We have Michael Mostyn here today. He's the CEO of B'nai B'rith Canada. He's going to tell us a bit about the organization and its charitable work. So I'll give you the floor, Michael. Take it away.
Great. Well, thank you so much, Peter. And again, thank you to everyone at Wagner Sidlowski for highlighting B'nai B'rith and the great charitable work that we're doing. Of course, all of your donations for our food program are welcome. We help hundreds of families below the poverty line, but also many that are immunocompromised, still aren't able to get out and shop, even if they had the resources to do so. And we've built up a volunteer network that every week delivers that food free of charge to those who desperately need it within our community here in Toronto. One of the things, and I know we've spoken a little bit about the varied activities over the last number of seminars that B'nai B'rith has been engaged in across the country. Something we haven't spoken about yet, which I just wanted to highlight as well about the organization, is our legal defense program. We have recruited many lawyers within our Matus Law Society in the fight for human rights for everyone here in Canada. And we're building up a legal defense program to take a stand on some of the pressing legal issues of the day, a couple examples of which are recently we actually launched a lawsuit against McGill University for creating an anti-Semitic climate by having repetitive motions by the student council, which were contrary to the bylaws of the institution. So that is something that we are pursuing in court because, of course, every student at every university in the country should be free to get an education and not have to deal with matters of racism. Another example of an injunction that B'nai B'rith was recently involved in was with respect to the Iranian soccer team that was doing a friendly against the Canadian soccer team. This was last spring. Some of us might remember this from the headlines, but they were going to be accompanied, the Iranian team, by the IRGC, the Islamic Revolutionary Guard Corps of Iran, half of which is recognized in Canada as a terrorist organization. And these are individuals that very much have been targeting Iranian Canadians And it's very unfortunate, but we brought an injunction very quickly in court because we wanted to see those funds, rather than paying the Iranian soccer team, we wanted it to go to the victims of PS-752, of course, the Ukrainian aircraft that was shot down by the IRGC in Iran, and many Canadians unfortunately lost their lives on that flight. Within 4 hours of the injunction being served on the Canadian soccer team, that friendly was canceled. So we are having an impact through the use of the law in the fight for human rights and freedom. And with your support, we can continue to do so. So once again, thank you so much for the opportunity, Peter, to speak to everyone. And I wish everyone a very successful seminar today.
Thanks, Michael. Thanks again for giving us that discussion. Really insightful. Again, there's going to be a link in the chat if you're interested in donating to the B'nai B'rith. We always encourage you to do so. Okay, we're going to start with the seminar. Again, the subtopic today is the role of the drafting solicitor in will challenges. So I'll have Brad and Tanisha take it away.
Thanks, Peter. Good morning, or I should say good afternoon, everybody. So I'm going to start off, and then Tanisha will continue. The initial takeaway is that drafting a simple will may not be nearly as simple as some drafting lawyers perceive. And that perception may be true when you're dealing with a healthy younger client who is, for example, leaving the entirety of his or her estate to their spouse, and in the alternative to their children equally. But beyond that particular and frankly rare scenario, things can get more complicated quickly. And as a result, unfortunately, it is quite easy for a drafting lawyer to find themselves in the midst of a will challenge application in some capacity. They may find themselves as a witness, or in a less desirable scenario, even as a party. And the obvious reason for this is that will challenges are most typically founded on the basis that the testator either lacked testamentary capacity or were unduly influenced in making the new will. And as the expert in the room when a will is drafted, the courts have concluded that it is up to the drafting lawyer to satisfy themselves that their client has testamentary capacity both at the time the will is drafted and executed, and that they were not subject to undue influence. So to begin, let's look at what these obligations entail. In the seminal case of Murphy and Lanfier, which is referred to in the paper we prepared for the seminar, the court, in language that no judge would use today, eloquently stated that in the case of a person greatly enfeebled by old age or with faculties impaired by disease, and particularly in the case of one laboring under both disabilities, the solicitor does not discharge his duty by simply taking down and giving legal expression to the words of the client, without being satisfied by all available means the testable capacity exists and is being freely and intelligently exercised in the disposition of the property. So in fact, in determining the scope of this duty in Hall and Bennett Estate, the Court of Appeal for Ontario explained that where a lawyer believed he did not have sufficient instructions to prepare a will and that his client lacked testamentary capacity to do so, it was the lawyer's duty to decline the retainer. So in that case, the court found that there was overwhelming evidence that the client lacked testamentary capacity. The difficulty, of course, is that overwhelming evidence is often in the eye of the beholder. So it's not, for example, atypical for a person with dementia to have their good days and their bad days. And moreover, just because a person has some level of dementia does not automatically mean that they lack testamentary capacity. And frankly, declining a retainer has its own risks. And Tanisha is going to talk about this in greater detail later on. But if, for example, a disappointed beneficiary was aware that the deceased had made an appointment and it tended to change their will, but the lawyer refused to do it and then passed away shortly thereafter, that would not likely preclude that beneficiary from bringing a claim against the lawyer on the basis that he or she ought to have proceeded with the preparation of the will. So there are risks inherent in both acting and not acting when there are issues or concerns regarding testamentary capacity. So given that there is this duty to assess testamentary capacity on the drafting lawyer, what should a drafting lawyer do? Rule 3.2-9 of the Rules of Professional Conduct provides some guidance on this because it states that when a client's ability to make decisions is impaired because of mental disability or some other reason, the lawyer must, as far as reasonably possible, maintain a normal lawyer and client relationship. So the question that arises is, if the drafting lawyer has an obligation to maintain a normal lawyer and client relationship if possible, what should they do? Well, step one requires that the drafting lawyer must ask probing questions of their client to assess their client's testamentary capacity. And we'll be talking about the types of questions to be asked later in the seminar. But as a lawyer who's done law pro work for 20 years, to paraphrase the old saying about whether if a tree falls in the forest and no one is there, does it make a sound? If a lawyer asks the client a series of wonderfully probing questions, but does not take contemporaneous notes, did it really happen? And the answer to that question is that 9 times out of 10, absent contemporaneous notes being made of those questions, a court is just not going to accept that the lawyer did in fact ask those questions. They are going to assume that a reasonably prudent lawyer would have taken notes when asking those questions, and if there are no notes, there were in fact no questions. Even if that's not true, the benefit of doubt will not be given to the lawyer. So what is really imperative is that you ask probing questions and take detailed notes of both the questions and responses you receive, because it is this contemporaneous record taking that will be critical to a will challenge case and may also serve to protect the drafting lawyer from being added as a party to the proceeding rather than just being a witness. But assuming for the moment the lawyer does have some concerns, but are not satisfying that there is overwhelming evidence of incapacity, it is likely that the court would conclude that it is appropriate in those circumstances for the drafting lawyer to proceed with the preparation of a will. And I say likely because, again, overwhelming evidence is often in the eye of a beholder. And if a judge thinks the evidence of incapacity was overwhelming, while you or the drafting lawyer did not, the court could conclude that the retainer should have been declined as opposed to action taken. But generally, as Justice Collody stated in Scott and Cousins, which is also referred to in the paper, careful solicitors who are in doubt on the question of capacity will not play God or even judge, and will supervise the execution of the will while taking and retaining comprehensive notes of their observations on the question. And this diligent question asking and note-taking approach applies equally when attempting to ascertain whether a client may be susceptible to undue influence. And I don't propose to go into a detailed analysis about the meaning of undue influence, but for those in the audience who may be new to the estate field, undue influence in the context of wills requires the court to accept that a person influenced the testator, amounting to outright and overpowering coercion. And in Sagan and Pearson, the Court of Appeal reconfirmed that in Ontario, the party attacking the will bears the onus of proving that the will was made due to undue influence. But that onus does not change the fact that a drafting lawyer has a duty to assess whether a will is being made due to undue influence. And practically speaking, some of the more obvious circumstances that should trigger the drafting lawyer to undertake a more in-depth exploration of testamentary capacity very often overlaps with the circumstances that could give rise to undue influence. So I'll give you an example of some what we call suspicious circumstances, and they're innumerable and they can't be comprehensively listed, but some of the most common examples include where an elderly testator is involved, or a testator who has suffered significant ill health, particularly that if the condition affects their mental abilities, will inevitably trigger or should trigger a greater focus on assessing their testamentary capacity. But if the elderly testator, for example, was brought to the office by a child or friend, and this client is new to you, and the person who brought the client in just happens to be a major beneficiary of this proposed new will, that clearly should set off alarm bells in respect of concerns about undue influence as well. So practically speaking, the answer into how to explore undue influence, just as it is for testamentary capacity, is really the same, which is you have to ask a series of probing questions that will consider the involvement of a beneficiary in the preparation of the will. And you have to take meticulous notes of those questions in order to properly reflect any concerns that you may have. And in that respect, it might be useful for the drafting solicitor to create his or her own checklist of the types of questions that they should be asking, both in respect of testamentary capacity and in respect of undue influence, when these types of red flags or suspicious circumstances arise. And if any of these suspicious circumstances are present, the most prudent option for a drafting lawyer to take would be to obtain an expert opinion on capacity. So while the capacity to make a will is ultimately a legal test, obtaining an opinion from a capacity assessor or a qualified medical practitioner is a prudent option to demonstrate that you've met the standard of care in considering testamentary capacity. And if, for example, the assessment determines that the person has capacity, albeit diminished capacity, that could also impact how a drafting solicitor proceeds if there are surrounding concerns regarding undue influence. And that may help inform their decision as to whether they wish to proceed with a retainer or decline it. Because concerns regarding undue influence increase with the diminished capacity of the testator. So now I'm going to hand off the discussion to Tanisha to continue this discussion. Tanisha?
Thanks very much, Brad. So I want to begin my part of the chat with talking to you about the potential liability of a drafting solicitor to third-party beneficiaries for drafting a will when the testator is unduly influenced or does not possess testamentary capacity, or in circumstances where that is the allegation. Generally, in a will challenge, the role of the estate trustee as a representative of the testator is to argue for the validity of the will, and it is someone else who is challenging the will. In that context, the drafting solicitor's client was the deceased testator. The duty of care, you would assume, would have been owed to that deceased client. But what obligation does the drafting lawyer have to a third-party beneficiary in the context of a will challenge that alleges that that testator was actually unduly influenced or did not have testamentary capacity? In those circumstances, the court has generally noted that the duty of a drafting lawyer was to protect the testator from making devices of his or her estate other than those that they actually intended. Traditionally, the courts have also recognized, though, that lawyers who draft wills may be liable to the people the testator wanted to benefit if, as a result of that lawyer's negligence, those intended beneficiaries did not receive their inheritance. For example, where the solicitor has negligently excluded a beneficiary from his or her rightful bequest, contrary to the testator's true intentions. Now, what do I mean by true intentions? Generally, when the court uses that language, they are referring to the intentions of the testator when possessed with the true requisite testamentary capacity and not subject to undue influence. So in those circumstances, what the court will say is that the testator and the beneficiary would presumably have wanted the same thing, presuming the testator was capable, and the allegation is that there was negligence that the drafting lawyer involved in the process that created a situation where the will does not indeed match those true intentions. This specific scenario came up in a decision called Vincent and Blake. It's a 2013 Ontario decision. In that case, there was a woman named Orly, and she passed away 2 months after she made her 2 wills and did an estate freeze. Orly's son David came forward and claimed that his sister Janice had actually unduly influenced their mother, and that their mother wanted, instead of what actually happened, to treat him and Janice equally under her wills. David sued the lawyers who had drafted the wills and had implemented the estate freeze. Now, the law firm brought a motion for summary judgment on the basis, in part, that David did not have standing to sue them because they did not owe him a duty of care as a beneficiary under a prior will. In that case, the law firm was not granted summary judgment. The court found on an analysis that will be specific to each case, you'll hear me say that fact specific is important, that it was possible in that case that the solicitor owed a duty of care to a beneficiary under a prior will, where the interests of the beneficiary were in fact aligned with the testator's interests. In that case, David wasn't directly challenging the validity of the new wills. What he was saying, or what his lawyers were carefully able to argue, was that the new wills did not follow the testator's instructions to the drafting solicitor with respect to her property. Now, what the court said in the decision is this. The court said, I acknowledge that in situations where solicitors would be placed in direct conflict with their duty owed to a testator client, a beneficiary cannot assert a claim against a testator's solicitor. However, it is clear on the facts of this case, it is not clear on the facts of this case whether Orly's interests are in direct conflict with David's interests or whether they are in fact aligned or identical. There is clearly a triable issue, as there needs to be a determination as to whether Orly and David's interests are the same and whether what Orly intended was what David and Janice actually received from the estate. Therefore, whether a beneficiary will succeed against a drafting solicitor is going to depend on the facts of the case. Now, as Brad mentioned, a drafting solicitor may better protect themselves when they ensure that there's proper note keeping. Let's drill down on that a bit. One of the things that a drafting solicitor should keep in mind and be trying to reflect in their note keeping is that there was effective communication with the testator client. This would include ensuring that the client and they both understand what the instructions that are being given are. What the drafting solicitor might consider doing then is, once this wonderful note-taking has taken place, make sure you're carefully reviewing the notes regarding your instructions against your own checklists that Brad mentioned, against the actual instructions that are reflected in the will. Make sure your notes actually match what you've written. Once that's written, you're going to send a copy of that draft to your client. Maybe it's useful that you do a reporting letter to regurgitate back to your client what it is you understand was instructed of you. A drafting lawyer may also better protect themselves via, as mentioned, adequate investigation of capacity and of the facts of the matter. Now you're going to, as Brad said, ask in-depth probing questions to evaluate capacity, and you're going to involve medical professionals or capacity assessors in the evaluation of capacity as may be necessary. And it might be necessary in all cases. As Brad mentioned, there may be some cases that you don't think it's necessary or a requisite step. But again, it's a step that you should consider and make sure it's not one that might be applicable or useful to your facts. One of the things you're going to do, as mentioned, is document all of the advice that was given to the testator and all aspects of the will preparation process. You should also step back, as we mentioned, and it's mentioned in the paper, to ensure that the instructions that you're receiving actually make sense and can be followed through on. You might consider confirming the assets, and this is something that Law Pro will tell you need to do, and the case law bears out. You should be confirming the assets and liabilities of the testator, and you should be confirming the marital status of the testator. You should also, as Brad mentioned, be aware of those red flags related to undue influence. For example, are you being instructed directly, or is there a family member who is not only managing meetings, maybe transporting an ill or infirm client to your office or setting up meetings, or are they going so far as to gatekeep the meetings or preventing private meetings? It could be anything along that spectrum, and it's something that you should, be alive to. You should also, as a drafting solicitor, be aware of whether there is a radical change from prior bequests under a prior will, and whether there's a reasonable explanation for that change. Now, I also want to talk about, and it's something that we've touched on at the beginning as well, is what happens when that lawyer is called as a witness. Because that drafting lawyer should and will likely have all this great contextual information in their file, the drafting lawyer will be key to any will challenge. If testamentary capacity or the presence of undue influence is an issue in the will challenge, the lawyer who drafted the will can be called to give evidence. The evidence of that drafting lawyer, and indeed the contents of the drafting lawyer's file, will be important to both sides of the dispute. It's going to provide a source of information regarding testamentary capacity and any tests of that. And as Brad mentioned, going to provide that contemporaneous record via those notes and records of the lawyer's own observations and own assessments of capacity or the presence of undue influence. Now, one thing to remember is that given, as I said, the testator is the client's lawyer, that testator has a right to expect confidentiality from his or her lawyer. And that means solicitor-client privilege will attach to the drafting lawyer's evidence and records. Now, this will mean that when the drafting lawyer is approached for disclosure of information, as helpful as you might want to be, this information should not be released unless and until the drafting lawyer obtains a direction from a person who is authorized to provide a direction on behalf of the testator, such as a personal representative. And indeed, what I might caution, I'll go into more detail on it, you've been provided with a court order for that production. And you can see that that may well be very necessary if the very authority of the personal representative is one of the issues that is necessarily in play given the will challenge. In the paper, there is a quote from Archie Rabinowitz, who is one of all of our colleagues at the Estates Bar, that suggests that the lawyer take one further step when a request is made by an executor or a personal representative for a provision of his or her file for the deceased. Archie suggests that as a measure of prudent practice, he recommends that whenever a named executor requests production of an estate planning file from a lawyer, the lawyer should request a statement in writing from the named executor, confirming that the executor is unaware of any challenge to the will, and where the executor cannot provide such an assurance, then Archie would suggest that the lawyer should not produce the file until ordered to do so from the court. And I've been involved in a prior session on order giving directions, and orders giving directions will generally contain such a provision. So it's something that the drafting lawyer should be alive to, and it's an easy thing for the parties to get for that, to satisfy that issue. So let's say a court order has been presented. We'll go a little bit further. We'll say that you should make sure that you should read the court order and make sure that the production that's being asked for is something that you can comply with. And if there's any doubt in the language of the order, it would be prudent for that drafting solicitor to retain counsel and bring a motion for clarification of the terms of the production order. Now, when you say retain counsel, you know, you've drafted this will, maybe you didn't charge very much for it, and you're thinking to yourself, what are my responsibilities now to incur costs to deal with this issue? What I want you to understand is that the prudent course of action in these circumstances would be for the drafting solicitor to, once you receive a request for production from your file, you should contact LawPro. It may not necessarily be that you have something to report from a negligence or a claims perspective, but LawPro may typically retain counsel on behalf of a drafting solicitor to review the request for production, review any draft orders for production that are proposed, and review any draft orders for production that are obtained if all this has happened before they've even involved you as a witness or a party. Now, you should also review the file before any production is made, and that's what LawPro will take care of. As noted in the paper, LawPro counsel will also seek to properly address the waiver, if it's not already been dealt with in an order giving directions, regarding solicitor-client privilege and the duty of confidentiality that had been owed to the testator. LawPro will also seek to address any form of payment for production for the file. And if an examination of you as a drafting lawyer is being requested, LawPro can also look into fees for attendance and the terms of same, and may well attend with you as your counsel at that examination. If the matter breeds a will challenge or a negligence claim against the lawyer, LawPro may also appoint defense counsel on behalf of the drafting solicitor. So if your client knows the particulars of his family, you know, all his close friends, what his property is, and to you, his or her, you know, intentions for the will, and you seem comfortable and you think, okay, this is a will that I can draft, this could well go a long way to you satisfying you. But what we are trying to instill in this presentation is that you must still be asking those probing questions and documenting them in your file so that while you're comfortable in the moment, you can demonstrate that comfort down the road if an issue does arise. As Brad mentioned, the tree could fall in the forest and nobody will believe it fell if there is no record of it. So In these circumstances, I'm many times appointed to be that lawyer that does the hand-holding for a drafting solicitor who is asked to make production or asked to attend for an examination. And practically speaking, when I'm acting in these circumstances on behalf of the drafting lawyer, the first thing I want to see is the original file that would answer the request. I want to see all documents. I want to see all drafts, right? Many times drafting solicitors don't think the underlying drafts are important. I want to see those. The parties will want to see them. I want to see notes. I want to see correspondence. I'd like to see the accounts, the assessments, and any communications with the client or anyone else who was involved in the process. I'm looking to see what is in the file in terms of record keeping and what the story that's going to look to the parties to the litigation or the court is going to be. For Archie's tip of having the information about the will challenge, I also want to know from the request or the order giving directions what the issues for the parties are and whether or not the drafting solicitor, whether they're targeted yet, could reasonably be targeted in the litigation. If the file is lacking on those issues, I'm going to want to know why. You know, it could have a situation where the notes did exist. Maybe they're lost for some inadvertent reason. Maybe they were destroyed. If they were never made at all of those circumstances will be important in the litigation, and your law pro appointed counsel is going to want to know what they are. And the reason I'm asking for all these questions is, as I mentioned, it assists from a perspective of whether or not there's a claim coming down the road. And if a claim has already been made, it assists with evaluating the merits and the likely and viability and success of that claim. So in terms of good note taking and record keeping, I'd like to see information and instructions from each and every meeting. I'd like to see written documentation of all the instructions. If they changed, I want to know when they changed, why, and the circumstances in which they were communicated. And so we're looking at everything. So as a drafting lawyer, you'd say to yourself, how much of my file am I keeping? How much note taking am I making? You're making as much as possible. And I'm going to come to the situation where, you're the drafting lawyer who charges on a very small fee or, very discrete, simple wills are what you specialize in. We'll talk about that in a second, whether all this work, fits into that context. But this is what I'm suggesting should be the benchmark standard for how you're operating that practice and that investigation. I might even be looking for video and audio recordings. There's case law that talk about that, of the testator giving the instructions or for the circumstances for the instructions. As we mentioned, medical notes and records or assessments are important. I'm looking for, this is a scenario that happens many times, that the testator may legitimately want to change their instructions and may have capacity and may not be subject to undue influence, but the will represents a marked difference to prior wills, or they're removing beneficiaries that previously had benefited under prior wills. I'd like to see reasons for why the testator is making that decision. I'd like to see that documented by the drafting solicitor, if not by the testator themselves. In the paper, we mentioned Kim Whaley's very helpful undue influence checklist. I recommend that to you to have a look through, because it does very much give you a listing of the questions, not only for undue influence, but also, as Brad said, the same questions can apply to the capacity analysis. So you want to have a look at that, and it might be useful to add to your own checklist for the questions you may ask of your potential clients. And just a few examples just to highlight from that checklist. You're going to be asking questions about the client's circumstances and family background. You want to know about the people who might have access to that client and who might be benefiting from the will changes or any potential exercise of undue influence. You're going to want to ask questions about the client's health, any changes to health, any imminent health concerns that would make the drafting of a will something that should be prioritized, any imminent health concerns that might make the client more susceptible to influence or to indeed capacity and the ability to understand their instructions. You're going to want to also ask about other professionals that are involved. I've seen numerous cases where the planning is not just a drafting lawyer. Accountants may be involved, financial advisors may be involved. You're going to want to know the context in which this plan is made and have that reflected in your file. That could 3, 4, 10 years later be an interesting and useful ability to understand whether or not testator did appreciate the consequences, did take advice in other circumstances, and did have legitimate reasons for the plans that are evident in your drafting. You're going to also ask about prior planning. Is there a prior will? How is this one different from the prior will? Why is it different, as I said? We've also included in the paper some sample questions that the drafting lawyer can consider. This is in addition to the checklist. And as I touched on a few moments ago, we very much recognize that we are creating kind of a gold standard listing of performance for a drafting solicitor. And while we recognize that it is a gold standard, or the highest or the most protected way you can try to address these issues, for those lawyers who do those simple wills and charge minimal fees, in our view, there is a great risk in not asking these questions, and the solicitors who do have that as a business plan should really evaluate whether or not that risk is something they are indeed prepared to take and whether it's worth it. So have a look at the paper in terms of those detailed questions. And I do mean they are very detailed. You're asking about assets, you're asking about things that are owned, whether or not they were already previously gifted. You're asking about bank accounts because the case law does suggest that you do have a level of responsibility for investigation of the information that you are being provided with. And you're asking about potentially, I've seen lawyers ask about potential for who might be challenging this will, because then that gives you a sense of making sure you document why those people are not included. So aside from that, and some questions that we want to go into, that will be my big part of the talk, and I'll take any questions with Brad as you might have now.
That's great, Tanisha. Brad, thank you so much for that discussion. I think that was really insightful. I'm going to open it up to the floor for questions now. Before I do that, I want to note that there is a certificate of attendance that Maddie will or has uploaded onto the Zoom chat, just to indicate that you've received the CPD hours for today's hour-long seminar. But anyway, I'm going to open it up to the floor now to see who's got some questions relevant to this seminar. Go ahead. Oh, I see Jason Moore has put his virtual hand up, so I'll let him ask the first question.
Thanks, Peter. Great presentation, Brad and Tanisha. I really found it informative. I noticed that one of the major themes here was just the importance of keeping information. So my question is more directed at the next step. I'm wondering what the responsibility of the lawyer who's drafting the will is to investigate the accuracy of the information they're being provided, and how they might go about doing that.
Thanks, Jason. So this ties into what Tanisha was saying earlier about the sort of the cost benefit of doing a simple will, because obviously there's a certain additional amount of effort that has to be undertaken to verify the information. So that means essentially, even if you've asked the probing questions and you've received a response, if your client says, yes, I own 123 Sesame Street, and they verify that, and they tell you that, and you say, okay, now they have an understanding of their assets because they've given me this information. But the reality is that all they've told you is what they've told you. It may necessitate that you take that extra step of actually getting a parcel register search of that address to verify that information. And I can give you a real life example of a case where I would say the lawyer did virtually everything perfectly. He actually was cognizant of concerns regarding undue influence and testamentary capacity. He made a detailed memo of his notes with respect to that. He sent the person out for a capacity assessment. So on paper, they did everything right. But, and this is the big but, is the lawyer didn't actually follow up with respect to the questions that were answered by his client. He didn't actually double check the information. And then the capacity assessor who concluded that the person did have capacity also asked similar questions, and they gave the same answer. So he told the lawyer, I own 123 Sesame Street. And the capacity assessor was told, I own 123 Sesame Street. The problem was that he didn't. The problem is that when you actually look behind the statements that were made, seemingly with confidence that both the lawyer and even the capacity assessor relied upon, it turned out that it was not accurate, that he'd actually transferred the property years ago to the son who just happened to be the one who brought him to the lawyer's office. So it changed the entire tenor of the case because of that absence of follow-up. So I think the answer is, and I'll welcome Tanisha as well, it's one of those things where I think in an ideal world, you could do some backup. You could do a parcel register search, which is not a huge undertaking and not a huge cost. Whether or not you would go to the extent of saying, okay, you've told me how much is in your bank accounts. Now I want you to go and get me those bank statements and bring them into me before I'll even consider it. Again, that is very fact specific. I would suggest that if in fact you had real concerns about either testamentary capacity or undue influence, and particularly if it's a larger estate, you may actually need to take those additional steps to satisfy yourself that what they're telling you is actually accurate, because that only bolsters your position. If a will challenge later comes up, you can clearly point to the fact that you were attuned to the issue, you raised the issue, and it may turn out that when you produce the document to the client, they may have an easy explanation about, oh, I forgot that, but here's this information, and suddenly what was an issue is resolved. So the short answer is there is a cost to doing it, but some initial simple steps, in my view, should be taken in addition to asking the probing questions and noting down the information provided in response.
And I would agree with Brad's thoughts as well. I mean, it's going to be fact specific, but if you are part of a complex estate plan, for example, surely there's some responsibility to understand, the assets that are at play in that plan. If you are, for example, an estate lawyer who's doing, simple wills in the air quotes kind of thing, and this is going to involve, tax consequences and major issues for the client, you should ask yourself whether you should even be doing those kinds of wills. And if you're doing them, do you have the in-depth advice information to allow for the advice that you're being hired to give? So again, super fact specific, and how far you go will very much depend on what's at stake. I think there's always, we keep coming back, we do law pro work, so we keep coming back to what's the best way to do it. And law pro would say to you that there is a responsibility not to be just a scribe, but to actually investigate the information that's being put to you.
Thank you.
I see Charles. Hi, Charles. Well, what can we call on Charles? He's got his hand up.
That's fine. I see both Mukta Batra and Charles have their hand up. Oh, and then I see another individual's got his hand up. We'll start with Charles. Go ahead.
You muted still, Charles?
I really loved your presentations today. But I have a question that people raise to me often. I'm talking about drafting solicitors. When is it time for me as a drafting solicitor to call in a capacity assessor? And I'd like a little bit of a nuance in your answer, if it's possible, both with respect to best practices and the minimum threshold, because we have to be very cognizant that many of the people on this call today aren't making a lot of money with their wills, as you focused on. Putting in another couple of $1,000s to get an assessor in there is very difficult, because it'll mean that they can't practice law the way they need to. So when is it an absolute necessity, and when is it best practices?
I think if you're alive, very much that there's going to be an issue. I think you're on the best practices end of the spectrum, but if you're not, we do talk about in the paper that it might be sufficient to have the doctor give you an opinion. I've seen many scenarios where the lawyer's notes indicate that they told their client to go have a chat with the doctor and have the doctor send them a note. And these doctor's notes can say, doesn't look like a nice, perfect capacity assessment, but it says things like, I've known so-and-so for how many years, I've treated them for so-and-so. These are the conditions that they have. I think that they understand, blah, 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 or I think they don't understand, blah, blah, blah. I've seen that as well, and in that scenario, I've had the situation where the lawyer drafted the will anyway, after the doctor said they don't have this understanding. So, that's the kind of thing that lawyer clearly thought about, but they didn't stop where they should have stopped. But to your question, Charles, again, it's going to be fact specific. So if you have a situation where you understand the client appears to be giving you instructions that make sense, the estate is not particularly complex, the issues that they're asking for are not particularly complex, and it appears that they understand, you might be, belts and suspendersing by saying, go talk to your doctor and have them send me a note. Maybe that's not even necessary. But again, it's going to be very fact specific. And I will keep saying, there is a risk to practice in that sphere. I'm not saying people shouldn't practice in that way. It's a reality. People can't afford $10,000 wills for a very, straightforward estate. And so I think the case and the facts and the expectations would bear that out.
I agree with you wholeheartedly. I would add one caveat. If I'm a drafting solicitor, I wouldn't be relying just on a paper or seminar. Everybody knows a good estate litigator, and if you don't, call Law Pro. Get some advice, because spending a little bit more time on the issue today will save you a lot of grief tomorrow.
Absolutely.
Thank you very much for that. I see Mr. Ristic has a question. Go ahead.
Oh, hi. Thank you to the entire panel for the presentation, as always. I was just wondering, in terms of what we are discussing right now, what is the golden best standard and how meticulous any solicitor has to be when even... But you have an appointment. I apologize. How meticulous every solicitor has to be in order to prepare even a simple will. And that the list goes like in very tiny little details. Brad mentioned really a very unfortunate thing where the lawyer didn't actually check the ownership of the assets apparently being disposed of by the will. I wonder, is there any end to it by way of kind of adjusting your retainer properly? First of all, simple will doesn't have to be the estate planning per se. That may involve like financial advisors and everything. And, simple will might be just retainer for simple will may just say, things in a very simplified way. So a little bit of that burden is taken off the shoulder of the drafting solicitor.
I'm not sure that there's a way you can essentially contract out of those obligations, but I do think that factual circumstances will dictate what you do. So to me, the simplest question that which is surprisingly not asked by lawyers, and in my view, even in the simplest case should be, is, do you have a previous will and can I see it? Because if you look at the previous will and it's a marked departure from the one you're being told to do, that should set off alarm bells. That will give you a really quick understanding that, even though it seems simple on its face, I now understand that this is going to be taking somebody out of the picture potentially, because the previous will divided my estate equally amongst my children, and now only one kid's getting it. And without that prior information, you may think on its face that you're dealing with a simple estate when in fact it's more complicated than that. So I would say as a first basic step, that should be done in virtually every case to satisfy yourself. If it turns out you're dealing with somebody who's, dividing the estate equally amongst his children, and he has no prior will, and it's a modest estate, I don't think in that circumstance you have to apply this golden rule to that type of scenario. If you're satisfied based on some basic questions, you're asking them that they have capacity. But in the exact same scenario I just described, if it turns out that there's a marked change from the previous will, that might change everything I just said. Because then you are into question, you do probably have to probe further, including having potentially to satisfy yourself that the person's not subject to undue influence, in which case a capacity assessment may be needed, or at least some kind of feedback from a doctor. So to me, this a really safe question, and one that isn't really regularly done that I've seen on the law files that I deal with, is just ask that question. Did you prepare a previous one and can I see it? And if it's similar to the previous one, and you have confidence, you probably don't need to go much further beyond that. But if you see marked departures, once you see that, I think you actually have to go further.
Well, thank you, Brad. But my question was about ensuring that the assets are existing. That was your example, and I found it really cumbersome for example, for me to ensure that some, shares of the U.S. owned corporation are really valid, or that the property is really owned in Florida, like what I'm retained for. I'm not retained for to ensure that someone is 100% legit in terms of his thoughts, what is owned. I'm just retained to do the will. So, and some of those assets might be transferred fraudulently anyway, and someone might be delusional about owning them anyway. So my job is to draft the will, not to show the other person that the assets are owned or not, or at least I'm thinking about.
I think if I can just jump in there, I think let's begin with there's always exposure, right? People can sue you for anything they want to sue you for. So what we're talking about is how do you minimize the risk as best as you can? So to the extent that the search is something straightforward and simple, on the facts of the case, you might get an allegation that the lawyer should have done that. If the search is more in-depth, or as to your point, Mr. Ristic, the consideration is that even the information, even if I test it, I can't verify that it hasn't been fraudulently transferred, that there is not another piece of paper somewhere that hasn't been provided to me. That means the client doesn't own it. I think if you have that in your file, like if I was the lawyer who was asked to look through your file, and I saw that you took that step, and then on the facts of the case, we then found out that, it turns out, notwithstanding what was told to you, this was another scenario. I think that would be our argument. I'm not the judge, I'm not the judge on the day, but that would be our argument, that you indeed did enough on the facts of that case. So again, it becomes very fact specific, and it becomes, how much ammunition can you provide to your defense lawyer to say that you did ask the right questions and did probe enough, and enough being for the judge to decide on that day. But what do we have to work with?
Yeah, I appreciate it. So initially I asked, is it really hurt to put that thing in a retainer, saying that the solicitor cannot guarantee the assets or anything such as that? Because it seems to me that the lawyer is a scapegoat at the end for anything and everything, and everyone wants to sue the drafting lawyer, past beneficiaries, new beneficiaries, the estate trustee or whatever. Is there any way of stopping that madness somewhere where someone can pull the brake and say, hold on, this is not what my job was in the first place? That's all. But thank you very much. Your answers are really helpful. Thank you.
We've got another question here. I see it in the chat, or it was sent to Maddie and forwarded over to me. This is sort of a fact-specific scenario. The question is this: I was approached by an elderly person who had a form of dementia, a type of Alzheimer's. I insisted that medical evidence be provided before I would do a will, even though I had the opinion that this person had testamentary capacity. That elderly person then went to another lawyer, and now I'm being asked to be a witness. What are my duties? So I think, and if my interpretation of the question is wrong, let me know. But I think the question really is, someone asked me to do a will. They had a form of Alzheimer's. I asked for medical documents, although I was satisfied that they had testamentary capacity. That lawyer did not end up drafting the will. That's my understanding. Perhaps I'm wrong. They went to another lawyer, and now this particular lawyer who didn't draft the will is being asked to be a witness. And so what can be expected of them in a will challenge in this scenario?
So presumably they're being asked for a witness to be a witness with respect to their file or their evaluation that didn't lead to a will. I can see potentially the person who's saying the will isn't valid would want to know why that lawyer didn't do one. Did you refuse? Were you concerned? Should that second lawyer have been more concerned and should not have drafted? I would bring you back to the circumstance. If you're asked to be a witness, you're looking for a court order that allows you to disclose from your file or provides for your examination. Again, to the extent you were consulted and have solicitor-client privilege information, you're not releasing that without permission of the court. If there's a dispute or permission of the estate trustee, and I'd go so further to say you want the court order in that context that you've just described, because it sounds like there's litigation afoot. But yeah, it's a matter of what the order requires you to disclose. And again, you're reporting that to LawPro for LawPro to give you some advice as to how you're handling the situation.
And just to add on to that, I think Tanisha referred to it earlier, is that often these orders where there's an examination is sought of a drafting lawyer includes that the drafting lawyer is going to get compensated for their time, both in reviewing the file and or in attending on it. So
the builder's lawyer for Zelnick, they're not accepting his mortgage.
So in that case,
because it's
sorry,
not currently dated, and then the investment statements.
All right, just a reminder for everyone to go on mute if they're not speaking currently. Go ahead, Brad.
Thanks. So in your case, obviously in that scenario, it would make sense to contact LawPro. LawPro would likely include a term that you attend on an examination, but you would at least be compensated for your time preparing and or attending on that to address the questions that I think a court would deem to be relevant, in that you met with him, you made some kind of assessment, and it's reasonable for the challenging party to want to understand why presumably the retainer didn't continue.
All right, thank you. Before I forget, I know Mukta Batra had a question as well. Mukta, go ahead.
Thank you, Peter. My question was about potential conflicts and conflict of interest. Very often, the drafting solicitor is approached either to conduct probate or in any litigation. Can the drafting solicitor represent an executor in probate in any litigation relating to the estate or outside, not relating to the estate?
So, I mean, in terms of a conflict of interest issue, I would say that if there are issues at play in whatever's going on that harken back to whether or not there is a capacity issue, or that drafting solicitor shouldn't have acted, if there's any smell of that kind of scenario, that drafting solicitor may potentially be in a conflict of interest in acting to basically advocate one side or the other. Presumably, if they're acting for the estate, then they're going to be saying that their own will that they drafted is valid, but they could potentially be a witness in that scenario. So that might be a scenario where it would not be appropriate for the drafting solicitor to act. That being said, not everything ends up as a piece of litigation, and the first person that most beneficiaries reach out to is the person who drafted the will, right? They have the will. If there is a dispute amongst the family that's not yet at litigation, maybe they want the drafting lawyer to help them navigate that. That drafting lawyer obviously should be identifying the conflict and identifying the fact that their role may be very limited in those circumstances. They may take the position, I can't act at all, or maybe we've seen it practically speaking that the drafting lawyer in the scenarios, like the family lawyer in air quotes, that's the go-to person. maybe that drafting lawyer, Brad and I were talking about this, maybe that drafting lawyer is useful to negotiations. Maybe things don't need to be litigated. And so that the drafting lawyer can potentially advise, but I would always caution that that is a scenario that breeds a conflict of interest. So query whether or not that drafting lawyer, if they're involved, any of those parties has received proper legal advice for whatever scenario they agree on that doesn't get litigated ultimately, or maybe settles in the process of litigation. Query whether or not that lawyer is placed enough independently to be able to advise any party in that context. It might be that they may be useful to negotiations, but everybody who's involved has to get their own ILA to any agreement or any resolution.
Yeah, just to echo what Tanisha said, from a practical perspective, you may be prepared to deal with them initially, but ultimately, if it looks like settlement discussions are going to break down, I think you have to tell them or advise them that they should be getting off the record. And if they don't, I think you have to bring a motion to have them removed, because they are going to be witnesses to the litigation that is now going forward, as opposed to just being involved in negotiations. So from a practical perspective, it may be desirable to have them involved for some period of time, but ultimately, if the litigation goes ahead and they refuse to get off the record, or they indicate they are intending to be formally retained and acting in the litigation, I think it may necessitate having to bring a motion to have them removed on the basis of the fact that they can't be both a lawyer and witness.
Thank you.
Thank you both for that. If anyone has any other questions, feel free to ask them now. We're about to wrap up, but I think we could entertain another question if someone has one. Okay, all right. Well, I think we can conclude for today. Brad and Tanisha, thank you so much for presenting. I think this was a really insightful topic. Thank you for everybody who had some really good questions today. Our next seminar is going to be in 2 weeks. That'll be on July 5th. Again, we encourage everyone to attend. That one's going to talk about the originating processes. So whether you bring a will challenge by way of application or action. So we look forward to having you all back in a couple weeks. Just a reminder, the certificate of attendance has been posted onto the Zoom chat, so make sure you download that before you head out. Other than that, have a great rest of your week. Thank you again.
Thank you, everyone.
Thanks, everyone.